Ready? Start. Mr. Deputy Speaker, there is one more provision of the bill to which I want to draw the attention of the Honourable Minister, and that is clause 19 at page 9, which is bound to cause great hardship in some cases. It provides for taking possession of properties which are forfeited under this act. There may be bona fide occupants of a property, even monthly tenants. There are small people occupying one or two rooms in a property. Once that property is acquired, whoever may be in possession will be forced to go out of the property, and the coercive machinery of the state can be used against him. It says that the complete authority may order a person affected as well as any other person who may be in possession of the property to surrender or deliver possession to the competent authority. Therefore, every person in that property, whether a bona fide occupant or bona fide tenants or not, whether a small tenants or not, will be forcibly ejected from that property, which is bound to cause great hardship to some people. Further, no opportunity is given to those occupants of the property to make any submission or representation before the competent authority or tribunal. Therefore, this is a very rigorous provision which may not affect smugglers as such, but will affect very repressively bona fide occupations of property. If somebody takes up a tenancy of 2 rooms in a property for a rent of rupees 100 and does not know that it is a smuggler's property, after staying there as a bona fide tenant or occupant for some time, he is suddenly one day asked to get out of the property without any hearing or opportunity to show his bona fides, that is bound to cause great injustice. These are some of the matters which I hope the Honourable Minister will take note of. Before I end, I only hope that this piece of legislation, like many others, will not remain merely a gimmick but will be implemented properly. Let them be all implemented not for the benefit of the financial operators, but let them be utilized vigorously against financial manipulators. Otherwise, the whole purpose of the bill will be defeated. Mr. Deputy Speaker, I have a number of speakers from the Congress party here. Obviously, I cannot accommodate all of them. I will call them in the order in which I have the names here, and in order to enable them to make a meaningful speech, I will allow them 10 minutes each. The smuggler and foreign exchange racketeers are operating a parallel economy based on their ill-gotten wealth. In fact, they are in possession of fabulous wealth and are wallowing in luxury which even the grand Mughals could not dream of. I welcome and appreciate the objective and the spirit behind this legislation. This is the spirit behind the legislation. This is the first time during the last 27 years of freedom that a serious attempt is being made by the government to curb the dens of the smugglers and foreign racketeers, but as pointed out by my learned colleague Shri Somnath Chatterjee, there are many deficiencies and inadequacies in the Act itself. Therefore, the Act is simply tinkering with the colossal problem of the illegally acquired property of the smugglers and racketeers. The application of this Act is restricted to two classes of persons, although they have been categorized into four. This act will apply to persons who have been convicted for an offence under the Sea Customs Act, the Customs Act, or the Foreign Exchange Regulation Act for the first time, and then only if the property in relation to which the offence under these acts have been committed is of the value of rupees 1 lakh or more. The second category consists of persons who have been convicted under any of these enactments more than once, irrespective of the value of the property involved in the commission of the offence. So it comes to this, that if a person who has been convicted of an offence which involves small property of rupees 300 do not come within the clutches of this law, while a person who has been convicted more than once but in relation property valued only at rupees 200 or rupees 300 will come within the purview of the legislation. I do not understand the rationale behind this sort of categorization and the discrimination between these two sets of persons. The third category of persons are those who have been detained under the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act if in their cases, after review and after receipt of the report of the advisory committee, if any, the order have not been revoked. How we know that if a person is to be convicted, he is to be prosecuted in the first instance court, that is the magistrate court. Stop.